Uh, I am not going to introduce the speaker because I know him too well to introduce. I have given that job to Dr. Sriram Shekhar sir, who is our president. Before giving the mantle to Sriram Shekhar sir, a few words about IMO. We are a small, group of lawyers and chartered accountants and, business consultants who started this in 2016 after our accredited training program under the Ministry of Corporate Affairs. We have come a long way. We are doing some really, really interesting work, unexpectedly interesting work, and we are still in the in the learning stage of how to run it, because we suddenly got into a lot of
Yes.
limelight. Thank you very much for all for all the to all the speakers who are exceptionally famous and exceptionally busy to join us on weekends. And with that, I want Mr. Sriram Shekhar sir, Dr. Sriram Shekhar sir, to introduce today's speaker. Thank you.
Yeah, thank you, Emily. And very good morning, everyone. As we all know, that mediation has the power to resolve disputes peacefully and help build stronger communities. By addressing conflicts early and collaboratively, mediation can prevent the escalation of conflicts and reduce burden on legal system. In fact, when Emily was telling that, yes, IMO has come up with a lot of ideas. And in fact, the International Mediation Organization, in its efforts to bring awareness, what we do to continue conducting regular periodical webinars under the chairmanship of Advocate Ms. Ambili Menon, founder member of IMO, for shaping the future of global diplomacy and better local community relations. We are honored today, indeed, to have with us an extraordinary individual, and who is none other than Mr. Anil Xavier, who happens to be one of the pioneers of the mediation movement in India. As a matter of fact, we all like his speech, the way he really conducts his course, and we are indeed we are all fans of Mr. Anil Xavier, and he has made significant contribution, in fact, to the cause of mediation. To talk about much wanted subject today is, yes, mediation, the way Indian way, is going to reveal and decipher the Mediation Act 2023, its relevance and impact that we all face and come across day in and day out. I will please join me in welcoming the speaker of webinar today, Advocate Mr. Anil Xavier, IMI certified mediator, and also the founder of IIAM. Mr. Anil Xavier is a practicing lawyer for more than 3 decades. He has been involved in multi-party, complex civil, business, commercial, corporate mediations and whatnot, and arbitrations. And he is a member of Independent Standards Commission and Ethics Committee of IMI, Netherlands, and has been a lot of activity. In fact, he is a senior fellow in Dispute Resolution Institute of Hamline University School of Law, US. He is empaneled as international accredited mediator of the Singapore, Italy, Hong Kong, Japan, UK, and he has not left any of the Asian countries, and also some of the European countries. He is the president of IAM, and also is the vice president of Mediators India. He has presented multiple papers and published articles on ADR in various national and international seminars and journals. We are excited to hear from Mr. Anil Xavier and gain valuable insights from him with his extensive experience. Welcome to Mr. Anil Xavier. The floor is yours. Sir, please.
Thank you. Thank you. Thank you, Mr. Shekhar.
Yeah.
Ambali, I thought you were asking questions.
I want you to start off so that, see, okay, we are all very, sir, when it comes to act, if I allow people to ask questions, then it's going to be a flood of questions. We all have a lot of questions. The main question is where do actually, let me just straight away come to my question. Where do we fit in? Where do we fit in? Now, the act, in my concern is it going to be yet another like only giving space to judges, retired judges and people who really don't require, I mean, it is not opening the scope of or the ambit of the idea of mediation to be all inclusive is my real concern. And where are we? There are a lot of organizations like like us who are doing considerable amount of work. I mean, you know it better than me. So where do we fit in is it's a straight question. I don't want to be nice when it is you, because I know you can take it that way. So where do we fit in? And we know, as we are also learning the act, taking there is an age limit. There is, I mean, where do this accreditation and how is the state machine mechanism going to take it forward is very ambiguous. And if you have any clarity, and if I'm sure you will have much better clarity than all of us. So we need answers for all this, sir. I mean, actually, I am people who are missing this session is missing a lot. So I like to, ask all these straightforward questions because they are genuine questions. When the act has come, we were excited last year. This year, I think the excitement is depleting, but that is not the whole idea of it, right? I mean, the idea is to take it forward and do something about it. Even if our organization or any organization who's doing considerable work want to fit in, what is that? Where should we approach? What is the way forward, sir? These are I think I've asked all the questions together. Now you have to just answer.
Okay, Emily. So let me let me begin, because see, when you talk about mediation, let us forget about the past. In the sense, see, we always say that India had a very what we call historical tradition of mediation, and we have been doing mediation for a long period. But let us not go into that aspect, because that mediation is not something that we are talking about in the modern world. So when we look at mediation, or the present mediation, or the present mediation act, see, we should consider that the advent or the importance of the modern mediation was actually recognized when the United Nations came out with a convention, and when India went and signed the convention in 2019. So, see, that was when the UN recognized that mediation is one of the most prominent dispute resolution mechanism that is used in the corporate world. Or, see, because when you talk about UNCITRAL, that is the organization which looks into cross-border trade and commerce. And when we talk about cross-border trade and commerce, see, it is actually the reflection of what the corporate world gives. It is based on that the UNCITRAL makes draft laws. So the convention was made for the purpose of only one thing, that is to recognize mediated settlement agreements. See, in fact, I was part of the working group of UNCITRAL for a long period, and we were having a lot of discussions about whether you need a regulatory mechanism or an enforcement mechanism for a mediated settlement agreement. See, there were divergent views. Most of the European countries said it is not required because mediation is a voluntary step. It is a what you call a step where the party takes voluntarily, and he participates in the mediation voluntarily. He takes a decision voluntarily. Then why the enforcement should be mandatory, or there should be an enforcement mechanism? But the Asian countries mostly recommended that there should be an enforcement mechanism, because otherwise, see, the entire exercise will become futile. Because after the entire step is done and after a settlement is made, if it is not enforceable, then many people could make use of it as a stopgap arrangement till the actual litigation or arbitration begins. So practically speaking, it was a cultural shift, because people who think that, see, if I've agreed on something, why should somebody force me to do that act? Because I have agreed it voluntarily, then I should comply with it. So that you can say as a pure mediation, where the participation, the sitting in the mediation process and the outcome is voluntary. And of course, the enforcement also should be voluntary. But there are certain other countries where they thought See, people would make false promises, but they would not comply with it. So there should be a mechanism where the compliance, after you promise for doing something, the compliance should be made mandatory. So ultimately, after about 8 working group discussions, ultimately the institutional thought that there should be a convention similar to the New York Convention in arbitration, where the enforcement of cross-border mediated settlement agreement should be made as part of a regulated process. And therefore, the United Nations Convention on Settlement of or Enforcement of Mediated Settlement Agreements, or which is commonly known as the Singapore Convention, came in. And India was one of the first signatories along with the 44 other countries where we signed it. Now we have got 57 countries and almost 14 countries who have ratified it. So after the convention was signed, there was a hype in India saying that India is also a signatory to mediation or the Singapore Convention. And now, see, at that point of time in 2019, when the Singapore Convention was signed, see, we had mediations in 2 types of categories. One was the mediations conducted through the courts under the CPC. So under Section 89, when matters come up before court, it is referred to mediation. And then the mediation could happen. And then once a settlement is made, it comes back to the court and the court makes it as a judgment. So that was one type of mediation that was happening in India. And the second type of mediation that was happening in India was under the Arbitration Conciliation Act. Under Section 73, once a settlement is made, it is deemed to be an arbitral award and it can be enforced like an arbitral award. So these were the 2 types of settlements or 2 types of mediation that were happening in India at that point of time. But unfortunately, when the Singapore Convention came up, see, the Singapore Convention recognized only mediations which are pure and simple. That means those settlements which are made through the process of a court and which has got the status of a judgment was not recognized by the Singapore Convention. And secondly, settlements which are made and which has got the status of an arbitral award was also not recognized by the Singapore Convention. So that means the entire mediations that were happening in India were not recognized by the Singapore Convention. So then there was a strong requirement of a mediation law, which makes private mediations, because the court annex mediations are not recognized by the Singapore Convention. And mediations conducted through conciliation under the Arbitration Conciliation Act was also not recognized by the Singapore Convention. So there was a requirement for a law, standalone law. And standalone law was not only required for making the mediation process, but it was also required because under the Conciliation Act, we did not have any provision for regulating the profession of mediators. So if you are looking at a new profession of mediation, naturally there should be a regulation for mediators and there should be a professional body which regulates the mediators. So then this requirement was satisfied, but there was no steps to make the mediation law. Then after 1 year, since there was no step that was happening from the government side, the Supreme Court took an initiative and the Supreme Court said, see, let the Supreme Court start the initiative of making a mediation law, and then they will submit that draft mediation law to the government. So the Supreme Court made a 10-member mediation law drafting committee, in which I was also a member, and we made a draft legislation, and that was presented to the government. And the government, of course, through the ministries, different ministries were involved, and Law Ministry, Commerce Ministry, different interministerial suggestions were taken. And then a draft law was made, and that was presented before the Rajya Sabha. And that was the first law that was made. And that, in fact, was almost a replica of the draft law that was made by the drafting committee, by the Supreme Court. And subsequently, after the Rajya Sabha referred it to the standing committee, many suggestions were taken up. And then the standing committee was made, and the standing committee took the views of various stakeholders. And then the law was redrafted. And then,
Please mute. Yeah, thank you.
And then subsequently some changes were made. And after the standing committee made some suggestions, then again the Law Ministry made a 3-member expert committee under the chair of former Judge Justice Sindhu Malhotra. And in that 3-member committee also I was a member. And we made some total, redrafting, in the sense that has come out. Now you said, see, you are not very happy with the mediation law. So I should admit that maybe I was part of that committee which made you sad in the
I was
mediation law.
conscious about that statement, but I only said that I had a lot
No,
of.
I do understand, because see, in that committee there was a lot of debates that happened, because see, now the major criticism that has happened in the mediation law is that we have not ratified the Singapore Convention, and the enforcement of international settlement agreements are not accepted by India for the time being, even though we have a signatory to the Singapore Convention. See, it conveys a very wrong impression to the world, because see, once we sign a treaty, because in the Singapore Convention is a treaty. See, once we sign a treaty, and thereafter when we make a law, the normal global convention or the global custom is, once you sign a treaty, the subsequent law should be in tally with that treaty. But we have deviated from that. In the sense, we have not ratified the Singapore Convention, nor have we made any provision in the law which could ratify the Singapore Convention, because there was no provision to accept international mediation settlements made in other countries. But to be frank with you, there were some valid reasons for that. In the sense, there were some very serious apprehensions that were raised by the Home Ministry. And we had a long days of debate on that. And subsequently, the Prime Minister's office also intervened. There was a special, what you call, designate from the PMO who was there in the committee. And we discussed and we finalized that, see, for the time being, let this law be passed. And we are also in consultation with the Institute to raise this issue, because you should understand, see, even though 57 countries have signed the convention, except Singapore, there are no major countries who have ratified it. Because if you look at the ratifying 17 countries who have ratified it, they're all small countries. See, countries like US, countries like China, countries like England, see, all these major countries have not ratified it so far. So naturally, you should understand there is some, what you call, serious concerns. And those concerns have to be first addressed. And only then we can ratify the Singapore Convention. So forget about the Singapore Convention for the time being. So that will happen after maybe, I'm sure it will happen in after, see, because see, now we should understand the law is not yet notified. So only few provisions are notified. And only after the mediation council is formed, the law will be fully notified. So that will take at least another 6 months. And after that 6 months, after the mediation council comes in, maybe within the next 6 months, we may ratify the Singapore Convention. And then an amendment will naturally happen in the mediation law. And then there will be a new chapter included for enforcing the international mediated settlement agreement. So it is not that it is a law which doesn't look into the future. It will definitely look into the future, but the only thing is we couldn't make it in one go because there were some real apprehensions that happens. So once that is addressed, then the law will be again, see, within the next year, definitely this law will be amended again. And then the chapter will be included for enforcement of foreign international settlement agreements. So that is how we should look into the origin of law. And what the law puts forward is, see, your second what you call question was with respect to whether this law will also be hijacked by retired judges and they will be the mediators. Definitely not. Because if you look at the constitution of the Mediation Council, see, that was a very, very strong decision taken by the government. See, even though, as I said, the second committee was headed by Justice Indu Malhotra. See, when the discussion about the constitution of the Mediation Council was made, so normally, if you look at any law, even if you look at the Arbitration Act and the Constitution of the Arbitration Council, always the law stipulates that the chairperson of a council will be a retired judge of the Supreme Court or a retired chief justice of a high court. That's a normal convention. And if you look at the first law that was put forward in the what do you call, in the parliament, that law that law also stipulated that the chairperson of the mediation council should be a retired judge of the Supreme Court or the retired chief justice of a high court. But then the ministry was very strong, and of course, one of the lone members who dissented to that proposal was also me. I said, see, retired judges should not be made as the head of the mediation council because that will take away the entire spirit of the mediation council. So now if you look at the mediation, the constitution of the mediation council, the chairman is not a judge of the Supreme Court. He is a person, he's a, what do you call, a well-known person in the mediation field who will know about mediation and the mediation law. So that is an independent person. And there are 3 independent persons in the mediation council because there are totally 7 members. So the chair will be an independent person who is not a judge, who is a renowned person in the field of mediation. And the second, that will be the chair, and the second member will be a mediation academic. That means a known academic person from colleges or from retired professors or somebody who was dealing with mediation will be a member. And the third member will be a mediator, a practicing mediator from an institution or an ad hoc practice. So the 3 independent members are all from active mediation practice. And the other members are, of course, the Secretary of Law, the Secretary of Finance, and the Secretary of Corporate Affairs, the 3 ex officio members. And the 7th member is a permanent member who will be an executive director. So the Constitutional Mediation Council is totally neutral and totally professional. So there is no scope for any hijack by retired judges or taking away from the mediation professionals in that manner. And if you look at what the future holds, is, see, definitely whether we are going to be placed in a prominent position in the world market in mediation, or whether we are going to slip away in the same manner like arbitration, will be determined in the next 6 months after the mediation council is formed. Because if you look at the entire structure of mediation, because for the very first time, see, if you look at various laws from various countries, there are many similar provisions like the mediation law that we have made. But one exception that our law has is the Constitution of the Mediation Council, because no other country has made a statutory organization which will oversee and control the entire process of mediation. Because if you look at the Mediation Council's powers, see, they will determine the process of mediation. That is one thing. Secondly, there are 2 organizations apart from mediators that are relevant under the mediation law. That is, one is the mediation service provider, and second one is the mediation institute. So mediation service providers are those organizations which will administer mediations under institutional rules. And second one is the mediation institutes, which will provide training programs for mediators. See, these 2 organizations are now left uncontrolled because there is no provision to control them, because there is no organization to control it. So once the mediation council is formed, these organizations will have to be registered under the mediation council. And the code of conduct of mediators and the qualifications prescribed for conducting mediations or for the accreditation of mediators also will be decided by the mediation council. So like the, see, if you look at advocates and they are controlled by the Bar Council, see, similarly, there will be a very strict scrutiny or what you call supervision of mediators and mediation service providers and mediation institutes. That means the training programs will be regularized. The code of conduct of mediators will be regularized. The accreditation system will be regularized. So it means that the profession of mediation will be totally what you call a regulated profession. Because now if you look at the mediators, most of the mediators are part-time professionals because they have one profession and they do mediation as a part-time profession. So no profession will succeed if it remains like a part-time profession. It has to be a full-time profession. So the Mediation Council envisages that concept. So that is one thing that the Act has brought in, which is very peculiar to the Indian law. And another thing, if you look at the mediation, our mediation law is, we have brought in a concept of registering the settlement agreements and procuring a unique identity number so that it will not be misused. Because we should understand that unlike arbitration or litigation, mediation or a settlement agreement can be made if 2 parties and a third person mediator agrees. So it is very easy to manipulate settlement agreements by fraudsters. So once see, even if there is no dispute, say let us take an example of a loan by a private bank, like a non-banking financial institution. See, nowadays they take post-dated checks, they sign blank documents, all those things happens. See, what happens if now the banks get signed settlement agreements, post-dated signed settlement agreements, and give loan. So after the loan is defaulted, they get a ready-made document which can be enforced right away like a judgment. So these type of misuse can happen in mediation scenario, and that should be avoided, because otherwise the entire system will collapse. So that is why this unique identity number was envisaged, so that after a settlement agreement is made, it should be registered. And it is not mandatory that should be registered, because even if it is not registered, it can be enforced. But if a party questions it, then the registration becomes very crucial. Because suppose the party makes an allegation that this was not a settlement, it was just a document signed by a party who has got higher power, and I was forced to sign it. And this mediator is also one of the parties belonging to the other side. He's not neutral. But of course, when both sides agree that mediator gets an accreditation, or because even if you look at the law, it is not mandatory that all mediators should be registered under the mediation council. If both parties agree, any person can become a mediator. So that loophole is always there. So to avoid these things, see, this is one aspect. I'm giving you a clue. This is one aspect that was the problem in ratifying the Singapore Convention also. So, so to make it very clear, because arbitration or litigation, there is a streamline of procedures. But in mediation, there is no streamlined procedure. Only the settlement agreements comes out. So it can be manipulated in different manners. So even though, see, all of us are very enthusiastic about mediation and the promotion of mediation, there are a lot of apprehensions also behind this, because it can be misused by many people. To safeguard all those things, the law should look into all those aspects. So that is why there is a delay. There's a delay in this. But of course, as I said, all these depends on how the mediation council is constituted, because see, that there's a undue delay on that aspect, because see, as I could understand, see, the mediation council was almost finalized about 8 months back, and it was on the verge of announcement, but then suddenly the government withdrew that. And again, last in August, again the ministry was about to announce it. Again, now it has gone to a cold storage. So we do not know when it is going to come up, because now the government is busy with elections. So always the problem is mediation is not a high priority topic for the government. So it will take a little more time. But the thing is, the mediation law will come into effect only once the mediation council is made. Until that time, it is not possible. Yeah. So further questions?
So yeah, I have a very interesting, that in this curve, I have a very interesting thought which came to my mind. It has been a very original concept. The question itself is, but then since it is to you, I want to ask this. See, you are various recognized, autonomous bodies are doing giving training programs. For example, Supreme Court is giving in their way. Corporate affairs, I mean, under Indian Institute of Chartered Accountants is doing in their own way. Now, alike so many, there are a lot of people who get structured training programs from Harvard or where not. On mediation. So when you do this, don't you think as a country who is progressing towards or doing a lot of, going forward, even improving our legislation, making a legislation on mediation, we need to understand what to actually, a lot of people are training, a lot of people are spending money and training. So where do we, where do you see that all these mediators who are training 40 hours programs, some say 60 hours programs, I mean, it is so distorted and too difficult to, even I'm not even talking about understanding, justify. I mean, we also do that, justify this whole idea of producing mediators and telling them to mediate. How much, what exactly you think is a proper program, or how do you think this should be structured, especially when you are looking to construct a council to monitor this, and also you are been part of all these things. Okay, Anil sir, you have been part of the legislation. Now I'm sure council is also in some way or the other, it becomes a moral responsibility. In that process, what according to you is the right training, or how are you going to regularize it? He said, I mean, you don't have to diverge too much, but if there is any way in which you want to give some inputs, because I know most of the people here are mediators, have done some kind of mediation programs. So what do you have to say there?
No, see, if you look at the mediation trainings, see, it has got a lot of problems in the sense, see, there are more mediation trainers in India than mediators now. Because, see, everywhere mediation training is happening. Because, see, most of the mediators who have undergone training, even without doing even a single mediation by themselves, I know many people who have become trainers. See, just by undergoing a training program and knowing the theory, suddenly that person becomes a trainer. And he has absolutely no practical experience of doing mediation anywhere. So this cannot be what you call approved, not even tolerated. Because see, you are creating mediators who are not having any standard. See, 40 hours is not the criteria. Just by undergoing 40 hours training program, I am 100% sure that person cannot mediate. Because he knows what mediation is. He has got an introduction about mediation. He knows the prospects of or the law of mediation, or maybe the process of mediation. But the actual scenario of mediating is not that easy. So the mediation council definitely, because when the law was made, actually there were some debates that the provision for training or the requirement of training also should be made in the law. But I was definitely not of that view, because the law should not be rigid to control the process of mediation, because it is a ever evolving science. So if you put it in law, then any change has to be amended by law. So that should not be. And moreover, mediation should not be made as rigid as litigation or arbitration. It should be left a little more free. So that is why all these are put under the control of the Mediation Council, so that it can be regulated by notifications and rules. But definitely, I'm sure see, now you said about different training programs conducted by the Supreme Court under the MCPC guidelines, under the ministry. All this will stop, because now the Supreme Court, after the Mediation Council is formed, see, whether it is by the Supreme Court or it is by a private organization or whether it is by the ministry, they are all categorized under one concept of mediation institute. There is only one definition, that is mediation institute. Whether it is by the Supreme Court or by the High Court or by a private organization or by the ministry, they will have to register themselves as a mediation institute. And when they register as a mediation institute, any program that they offer, that curriculum should be ratified by the Mediation Council as per their guidelines. And the mediation service providers, they should have the requisite number of mediators who should have the prescribed qualification. What I mean by prescribed qualification is not just a 40-hour training program. It should be a 40-hour training program with the experience that the council will prescribe, and also the code of conduct and the other what you call paramaterials that the council will formulate. So maybe, see, once you complete your 40-hour training program, you will have to be a trainee mediator with a senior mediator, maybe for 5-10 mediations, or you will have to be a co-mediator for maybe 20 mediations. See, because if you look at IMI or the APCAM certification program, see, in IMI, you will have to undergo 250 hours of mediation before you are certified. So the problem is, how do you get that 250 hours? Because unless you are certified, you are not appointed as a mediator. And you will not get a certification unless you have an experience. So it's like a what do you call a catch-20 situation where neither of this can be achieved without the other. But you should understand one thing, because when the law was first made, mediation was made mandatory. That means for any dispute before it goes to court, the party should opt for mediation mandatorily. They had no option. But then when we had the second round of discussion, we said that it is not possible, because where do you get the number of mediators? Because if the entire India, the civil litigation has got a hurdle that it should be mediated first then you need at least, the minimum requirement that was assessed was we need at least 10 lakh mediators. So where do you get this 10 lakh mediators? But definitely now it is made as an optional thing because the party may go for mediation before going for litigation. But probably after the mediation council is made and the training programs are popularized. See, definitely in the next 3 years or maybe 5 years, mediation will be made mandatory, because without making mediation mandatory, the court docketing cannot be controlled. Because one of the major concerns of court is, see, I'm sure you must have seen the National Court Management's projections. See, now we have 4 million cases pending. And according to the National Court Management system, it takes almost 350 years to complete the entire what you call backlogs. So if you look at the present pendency of 4 million, it takes about 300 odd years to dispose of that cases. And the even more dangerous projection is by 2050, this 4 million will become 15 million cases. So the amount of backlogs and the amount of court pendency will be unmanageable after maybe 10 years. So definitely in the next 5 years, mediation will be made mandatory, and only after trying mediation and with a certificate of the mediation provider that you can apply to a court for a litigation. But for that, you need a big army of mediators. That is why this is a very strong body that is going to be formed, because like the advocates profession or like any other profession, in the next 5 years, there will be a new profession that is born. That will be the mediators profession, which will be totally regulated, and it will be a sought after profession because there will be enormous work that will be available once the entire civil litigation goes through the funnel of mediation. So there is no doubt that the mediation has got a good future because of the enormous number of litigations that we have. But the only thing is, unless we make it regulated, there will be so many fraudsters that will be available. And see, there will be many training programs which are going unregulated. So all these things have to be regulated, and definitely only approved training programs and only approved trainers and only approved mediators will be available. So that is the basic idea of this.
Another anxiety with respect to people who are not lawyers is that, Anil sir, how much inclusive?
Absolutely, there is no discrimination between lawyers and non-lawyers, because mediators will be a totally different profession. And anybody who undergoes the mediation training program and who will have the accreditation will be a mediator. There will be no stipulation that the mediator should be a lawyer or a non-lawyer. There will be no discrimination at all.
So you just need to be, I mean, according to you, you don't need to be a part of an institution to get that particular accreditation or being a part of this particular getting a member.
No, you have to be empaneled with the mediation service provider, because after undergoing an accredited training program, naturally you can empanel yourself with any service providers, because the service provider's duty is to submit the panel of mediators to the Mediators Council and get it accredited.
Okay. So definitely these institutes or these service providers will have a role as far as
Yes, see, now you can take it after maybe in the next 10 years, we will have at least some 10,000, 20,000 service providers.
That's very assuring.
Yeah.
Because probably when the mediation concept started, and at least maybe, as you said, in 2019, 18, 19, at that point of time, none of the organizations, I mean, please correct me if I'm wrong, none of the organizations, including us, we came together to start something, not because we were seeing this. We were really passionate about, and we really liked what we did and the training program and the scope of it to resolve it. And that is how it turned inside the lawyers and a few professionals like chartered accountants or cost accountants, who always had this role of, resolution in their mind, and always knew that, I think you so far ahead of us. I remember you doing being a mediator and talking about it and promoting it from ever since when I was a child or a student.
See, we started in 2001, And we had our first training program in mediation in 2003.
I know that. So we all started with that actual interest in promoting this. So now in this 3 years, as you correctly see, so there are a lot of people, who is coming into it. Probably, as you said, because this is something which is going to grow big way. It's going to be a compulsory pre-litigation mediation with respect to any disputes whatsoever, except with a few exemptions which we already know. Now, having in even mediation in 138 matters, the hopes are very high, because it could change the course of a law which was otherwise non-compoundable. So obviously that shows the impact of mediation. But the issue here is how far these structuring, I mean, that is also a concern. The structuring of it will wither away the essence of the skill, or the what do you call, the process itself. I mean, the skill of the mediation. When you straitjacket things into molds, obviously you will have to fine tune it, cut it off to fit in. So what is that flip side? What do you see? I mean, I like to know what is that flip side that you are contemplating.
No, basically, see, we cannot put a framework for the mediator's action, because see, we should understand that mediation is a science and an art. So the science part we can regulate, because see, what should be the way, because see, even the Mediation Act says it should be purely facilitated. So there can be no advice for the mediator. There could be no pressure from the mediator. There should be no suggestion from the mediator. See, all these are the science part of it. So what the Mediation Council will do is it will regulate the science, but the art part of it, because mediation is both a science and art. And the art part, see, it's like cooking. See, you go through the what you call recipe. Many people can go through the same recipe, but their cooking styles will be different. So similarly, the mediator's style of action will be different. That is how a mediator excels from another mediator, and why the party will choose a particular mediator. Because if everybody does the same thing, there is no fun in it. There's no charm in it. So the science part definitely will be strictly regulated, because there could be no way in which the mediator can manipulate the proceedings. But the art part of it, how do you do it? How do you tackle the parties? How do you look at the NLPs, non-linguistic programmings? How do you look at the body languages? How do you communicate? See, that is why I said the 40-hour mediation training program is just the science part of it. The art part of it will be an additional training that, of course, the Mediation Council is, see, all these are the powers under the Mediation Council which they have to regulate. But I'm just saying, these are the things that the Mediation Council will have to regulate, because, see, to become a mediator, understanding the science of mediation is not enough, because a mediator should be very clear about NLPs. The mediator should be very clear about body languages. The mediator should be very clear about the brain structuring, because in what atmosphere how the party reacts, what food can trigger negative emotions and positive emotions. See, many mediators I know, even in court annex mediation, see, normally you say we'll have a coffee break. See, when the people are fighting, and if you give adrenaline more, they will fight more. You are giving them more strength. So a coffee break is not an appropriate stage when the parties are fighting, because you give coffee, the adrenaline will be more and they will start fighting more. So you need to find out a drink which will pacify them. So a lime juice would be a better option than a coffee. So all these things are a serious consideration as far as the mediator is concerned. So what type of, you normally put biscuits or things. See, normally, see, how do you give more attachment to the party? How do you bring more confidence level to the party? See, even one dark chocolate can do that. So how do you promote those things? So these are the art things and the science things that will combine to make a good mediator. So the Mediation Council will definitely look at options and add on programs to the 40-hour training program. And there will be definitely multiple stages of accreditation. because maybe junior mediators will be accredited at the entry level, and subsequently you can add on to the accreditation so that you will become a more professional mediator. And definitely once we have, because see, even the present law talks about international mediations happening in India, but not mediations happening outside India and to be enforced in India. But already we are talking about international mediations being conducted in India. So definitely, I'm sure that the accreditation level for those mediators who are undertaking international mediations will be different, because there you need to understand cross-border cultural issues. See, even the body languages or the sign languages that we use in cross-border disputes, how that should be regulated. So all these things have to be understood by the mediator very clearly. Otherwise, the mediation will not be successful. So different, because mediation is not just a study of a particular science. It is a combination of many things. So it's a ever evolving profession, and definitely the council should have the what you call the vision to control or regulate all those things.
The fact that you said that this council will, take away even the power of the Supreme Court to conduct this mediation training programs under the MCPC, and even the other, like the Institute of Chartered Accountants, MCA, and all is conducting now. So that is actually a very. So you mean to say that the council will conduct probably training programs, or they will
Council will not conduct training programs. Council will regulate the curriculum, and the service providers and the institutes will do it.
Okay.
But see, the council is given very wide powers, because see, the council is given of course, the headquarters of the council will be in Delhi, but they are given the powers to open up offices in any parts of the country. And also, it's a permanent institution. It's not a part-time institution. So it's a permanent institution. And see, the government has actually, while making the law, the government has taken very serious note about the profession of mediation and the progress of mediation, because they think that mediation is one probable strong answer for access to justice in India.
So I want, there are a lot of participants. I want a few of them also. If anybody has any questions, we are almost in the fag end of the thing. So let me know if anybody wants to ask any questions.
This is Janaki here. Can you hear me?
Yeah, yes, Janaki.
Yeah, see, I saw a trend. See, I'm a practicing lawyer, and for me, introduction into mediation itself was a eye opener, because it was a total unlearning of what I learned over the past 30 years as a trial lawyer. So it was a completely divergent thing. And only when I attended the program, I realized the difference, the total difference between both the lines of practice. So, and I'm very enamored by whatever I learned. So from that point of view, and having practiced, I also notice a trend that when there is a court mediation, or when a matter is in court and the judge feels that this should be referred for mediation, for whatever be the reason, they are automatically suggesting a retired judge. Okay, so because he must be having a thought process, and the see, I'm not taking any names, but this happened very recently, and the judge also happened to be a trained mediator, who is now sitting as a judge and who is referring a matter to another judge as a mediator. Now, I'm not questioning that also. There must be reasons why he is particularly asking it to be, because it's a very big corporate matter. And in such a scenario, why is it that they are not considering people, since it's a corporate litigation, and it's, how do I say, a more, should I say, relating to company and all its nuances? Why is it that they are not thinking of having a co-mediator from a profession which is not that of a legal profession? Because it would be an additional advantage. Plus, also, these people who are coming out as trained mediators are not, like you said, are not getting enough training practically. And how do they gain practical training if you're a court appointed mediator? you will get your, as you're enrolled there, you will automatically get your experience and your exposure. But the remaining, the private mediators, unless matters are referred to them and they get exposure like this, which, with the help of a judge who is all, who is also a mediator, will that not actually help? Because having a judge, yes, it's fine, I'm not questioning that. I'm only saying the others need to be trained, and these people who are coming out from the institutions, it can be a chartered accountant or it can be, anyone else. Should there not be a, why is it that you're having only one mediator? Again, that tendency note of retired judges coming in.
And of course, that is actually a very valid suggestion, and that is being seriously considered, because one of the ways in which the junior mediators could be brought in is a mentoring by the senior mediators, and naturally, co-mediation is one aspect by which the junior mediators can be mentored properly by the senior mediators. So definitely, the new structuring that will happen under the mediation council will take a, I'm sure that will be taken care of, because because in most of these court mediations, because the party is not bearing expense, because in private mediation the problem is the party is bearing the expense. So they may be apprehensive of having a co-mediator because they may also charge. So unless the institution rules provide that the trainee mediator is coming free of charge, then otherwise, so there are two issues. One is about confidentiality, because the uh, the party may not be confident that a junior mediator will will take care about the confidentiality matter. But definitely, all these are regulations which will come in after the mediation law is properly made. Because see, right now the problem is we do not have a law to regulate this, and only the rules that are formulated by the high courts under the NCPC guidelines regulate these processes. So once the law is made and once a professional body takes over this concept, then definitely all these things will be considered. And I'm sure the council, once it is made, they will have constant interactions with the mediation community, and they will continue to get the inputs from the mediation community as to how that should benefit the young mediators to grow. Because see, definitely one thing is there, because every country, because it is not just India. Now, after the Singapore Convention is made, every country is vying to become one of the top most preferential places for mediation. Because, see, one difference that we have in mediation is, unlike arbitration, mediation is not seat-based. That means, see, in arbitration, the arbitration is seat-based. That is, you have a jurisdictional seat, and that arbitration is deemed to be conducted in that place. But in mediation, there is no concept of seat. So any mediation, whether the dispute happens anywhere in the world, the mediator can be picked from any country. So that means a country who can supply good mediators will be in very high demand in the global market. So every country is vying for that, and every see, not only the developed countries, many developing countries. I know many countries are doing extremely good programs to make good mediators, because they know that the mediation market is going to boom. Because there are not only dispute mediations, deal mediations, another aspect. Because most of you who are chartered accountants will be very interested to have that, because deal mediation is something that is progressing in a very big manner.
Good.
Especially in mergers and acquisitions, the role of the deal mediator is becoming very prominent in international matters. So the country which produces good mediators will always have a good stand. And definitely when a standalone institution is made like the Mediation Council, their intention will be to create good mediators. And good mediators are not created by training. Good mediators are created by training with experience. So naturally, there will be provisions made for getting experience, or the what do you call the exposure to the real disputes, to mediators, to make them efficient and make them proficient to take up serious matters. So I think the apprehension that Janagi has made will be duly considered once the Mediation Council takes charge. Yes, Sangeeta.
Hi, good morning. I came late because I had an online mediation going on from 11 o'clock. That is why. So I
Okay.
just want to know about your opinion regarding shadow mediation. because Janaki is so very right when she says, and that the judges always prefer judges ki unke hi naam they come up with. We don't have any qualms about it, but the thing is, we want, I mean, the court referred mediation also, it's not very much, say about once in a month or something like that. But the young mediators, they must have the exposure. So you people, I mean, you are a established name in the ADR scenario in the country, so why don't you take this up? That shadow mediation and co-mediation, we don't want, I mean, any money for that. It's not the money, only the exposure, that's all. If they want, and now there are only online mediations, we can, I mean, I also include myself also, so we can always keep our video off and the audio off, but we will just uh, go through the process. It helps a lot.
Yeah, shadow mediation is a good way of what do you call getting experience. And
Correct. So,
the only thing is, see, for institutions, um, actually, we are bringing out a new rule this year, because unless we have a provision specifically made in the rule, because see, most of the private mediations happens based on mediation agreement. Because the companies will incorporate a mediation agreement in their, like an arbitration clause, there will be a mediation clause in their contracts, and
yeah,
they have agreed to do mediations under the particular mediation rules. So
correct.
unless there is a specific provision in the mediation rule which says that the mediator or the institute can bring in shadow mediators,
Yeah, yeah, yeah.
so we are actually we have made a proposal to the rules committee, and because now we have come out with the expedited arbitration rules which provides that. Similarly, we are bringing out a change in the mediation rules. So probably very soon we'll be doing that.
That's a very good news. Good news, absolutely.
Maybe two more questions we can take. Actually, we've already.
One short question I wanted to ask is, you have this legal aid center attached to the courts, which is supposed to actually help the marginalized people. But how far it's actually helping is a matter of opinion. But can we have some, do we have, or is there anything envisaged where you can have something like that for mediation? Because not everybody who comes for mediation can afford mediation cost, whatever be the cost, whether it's 100,000, 10,000, or whatever. But is there something, especially the matrimonial things, when you're referring for mediation, something like a legal aid center, which can, really help the people who need it?
See, there is a provision under the mediation law itself for creating a mediation fund by the mediation council. So, see, one thing you have to be very clear, because see, whenever people think about mediation or talk about mediation, especially when judges talk about mediation, they will always project mediation as a service, because they always quote Mahatma Gandhi saying that, see, it was a service, and you should become a Mahatma, and you should do service voluntarily, because see, no profession will thrive unless it is a what do you call earning profession. See, you can do voluntary things for the time being, but you cannot survive in that. So mediation has to be a rewarding profession. And see, when you talk about mediation in a commercial matter, see, so for example, suppose it's a 1 million dispute. And if you're going for litigation, you're paying the court fee. When you talk about arbitration, normally people say it is expensive. But I can tell you, no arbitration in any institution will cost more than 5% of the what you call the total dispute value. But if you talk about court fee alone, see, for a state like Kerala, we are paying 7.5 to 10% of the dispute amount as court fee, and nobody is considering that as an expense. And you are saying arbitration is very expensive. So when you talk about arbitration or arbitration or litigation, you are paying somewhere around 5 to 10% as the expense. And when you're talking about mediation, see, arbitration, let us say it completes in 12 months, and let us say the execution takes another 1 year. So the entire process completes about 2 to 3 years. And if you're talking about litigation, the entire process completes in about maybe 5 to 15 years. And when you're talking about mediation, the dispute is getting over in about, let us say, 2 weeks or 3 weeks. So why is that? See, actually speaking, in a common sense manner, the party should be paying more than above the 5% or 10% because they are getting the relief in a very short period of time. But forget about that. See, why not at least pay, let us say, 2 to 3% of the litigation cost or the dispute cost for the mediators or the mediators profession? So we need to change that attitude that mediation is a service. Mediation is a service, as you said, for legal aid. For certain groups of disputes, mediation can be a service. But to make it as a service, the service provider should have enough and sufficient funds to give that pro bono treatment to those parties, because they should get the money from corporate disputes or commercial disputes. And the mediator also should be available for doing pro bono matters only. Maybe let us say, suppose he does 10 commercial matters, we can make it mandatory that he should do 1 pro bono matter. But you cannot do 10 pro bono matters continuously without earning anything unless you have a standby profession. So when you're talking about mediation or the mediator as a standalone profession, you cannot visualize that profession as a pro bono service all throughout. It has to be properly rewarding. See, unless, suppose you are shifting yourself as a mediator, a full-time mediator. See, unless you make maybe 2 to 3 lakhs a month minimum, see, how do you expect that professional to survive? So your mediation definitely have to be a rewarding profession. It has to be a self-sustainable profession. And of course, for matters which are marked as pro bono matters, the mediator should be available to do that.
That's exactly what I meant. That one portion of it can be, done pro bono.
Definitely. That's what type of disputes and who are eligible to avail that. That should be a regular guideline for that.
Category.
And the mediator who can, because see, in mediation, what we proposed was, see, just because you got a training and you are accredited, you cannot continue for your life as a mediator. There should be a regular renewal of that mediator's accreditation. At least, let us say 2 years or 3 years, there should be a renewal. And for that renewal, see how many mediations you have conducted. And for the number of mediations you have conducted, let us say a commercial mediation, how many pro bono mediations you have conducted. That also should be recorded for your renewal.
Yeah, I agree. That's,
Yeah.
that's fair enough.
Thank you very much. I mean, we have overshooted the time. Thank you very much, everybody.
I think one hand is raised, TMA.
Oh, okay. Yeah. Please go ahead. Yes.
Good afternoon, everyone.
Hi, Gupta. Yes.
So, Anil, you spoke about deal mediation. So, I think deal mediation would be very effective in a situation of a turnaround of a stressed business or an insolvency situation, because mostly the stakeholders would
Can
have
you be a
certain
little more
issues
louder?
on which they need
Can you be a
to.
little more louder, Gupta ji? Can you be a
Yeah.
little more louder?
No, deal mediation. See,
Do I
insolvency.
need to?
No, I understood the question. So you're talking about, see,
Yeah,
deal
please go ahead.
Yeah, so
Yeah.
insolvency or a company dispute where the stakeholders and the company are involved is actually a dispute mediation, because there is a dispute already. But in deal mediation, there is no dispute at all. That means 2 parties, see, instead of negotiation, see, earlier it was like bilateral negotiation, but now instead of bilateral negotiation, they are appointing a mediator to navigate that negotiation. And the output, see, what the statistics show is, the output or the end result that the parties get out of that deal mediation is much better than a regular negotiation, because the mediator can navigate the discussions in a better manner, and they can come out with solution, what you call results, which are much beyond the expectation of the parties. And mostly these deal mediations are done like, see, the parties and the mediator will fly to a particular destination, and they will have the negotiations done there, and they will come out with the deal, and they will fly back. So it is like a concentrated effort by the mediator and the parties to come out with a better deal. So it has nothing to do with dispute.
Since we are handling turnarounds and insolvency, most of the time there is some sort of a negotiation that needs to take place between different stakeholders to come out of that difficult situation. So that's why I said that when we talk about turnaround, there's probably a problem between a creditor and a debtor. They want to negotiate something which they cannot do it because of lack of laws, or because of there's some issues which do not have any resolution.
No,
Right.
that is, no,
In that context, I was talking about deal
yeah,
deal
that
mediation.
definitely happens in dispute mediation also, because in dispute mediation, what the mediator does is he helps negotiation between the parties.
Okay.
Yeah, I think Abhinaya
Thank you. Thank
Mogam
you.
has a question. I thought you raised hand. Okay. Okay. So I think we have overshooted the time.
Yep.
So if everybody agrees with me, I want to conclude because it's already 12 o'clock. We started at 11 sharp. I am very grateful to be a part of this metamorphosis of mediation and living in a times where there's a drastic change in the way we see disputes and the various ways that we are thinking it could be resolved. That itself shows that we have done justice to justice to the civilization that we are living in today, because mediation when it was when at the time when Anil Xavier was talking about mediation, nobody took him seriously. I'm sure he knows that. He know that I myself know, because we grew up almost in the same town together, seeing each other. Our parents were friends, so that way. But today, I mean, that's why I said I'm so happy to be the part of this metamorphosis, and I'm still happy that I could, I could organize programs to call Anil Xavier as guest, not once, twice. I think last time we had an abrupt, ending. Because it was due to overload, Anil sir, because minimum 120 participants were there and we didn't know what to do. The whole thing crashed. It was during the COVID period. And we are looking forward to call you more. And the best part of today's mediation plus the technology, last time I remember the discussion was, do I have to think of do I have to impress upon my daughter to get married to a technology guy because she's studying for law and maybe she's also serious about mediation. But today that issue is somewhere he answered, not always necessary, but it makes sense because hand in glove, both mediation and technology. I think it will definitely take the world, and obviously India should be a major player, and we all look forward to be part of it and grow together. Anil sir, we will again want to call you and get benefited out of this, hand in glove thing of technology and growth of mediation. That's why we are able to have you today. And we are so happy to, you have actually answered. I know where you are today and how busy you are on a Saturday morning. You answered most of the questions, and I'm sure you kept us all so engaged. Thank you very much, Anil sir. I will keep in touch with you. We will again want to call you. Maybe I want to do less pro bono and start paying people whom I even call as speakers one someday. I hope all of us together, with the help of Anil sir and Sangeeta ma'am and all of you together, help us bring mediation to that level.
Thank you. Thank you.
Anil, I must say it is a pleasure listening to you all the time, so I don't miss. So please, Jabibi, whenever you people come for this kind of a session and all that, put me in the mailing list.
Yes, ma'am. Sure, ma'am. Sure, ma'am. Sure, ma'am. Thank you very much, Anil.
Thank you.